I want to talk to you about a recent California Court of Appeal decision that has now rendered Howell versus Hamilton meets in Provision Zeke completely toothless, providing the plaintiff's bar with a loophole to sidestep Howell's holding. Pebley versus Santa Clara Organics LLC held that even if a plaintiff has medical insurance, that the plaintiff may seek medical treatment outside of his insurance plan. By doing so, the court explained that the plaintiff should be classified as, quote, uninsured for purposes of Howell, and that the plaintiff's full billed medical expenses would be admissible to determine the reasonable cost of the plaintiff's medical treatment incurred. All of the decisions that focus on medical expenses are grounded on an application of the collateral source rule. That rule provides that if an injured party receives some compensation for his injuries, such payment should not be deducted from the damages which the plaintiff would otherwise collect from that tortfeasor. Even though a plaintiff's medical expenses may be paid for in full from his medical insurance, the plaintiff is still entitled to recover from that defendant at trial the reasonable costs of those medical expenses incurred. This typically meant that a plaintiff could submit to the jury the full amounts billed by the medical providers for treatment as evidence of the reasonable costs of medical expenses incurred. Most insurance carriers have pre-negotiated rates with medical providers where they pay only a fraction of the amounts actually billed. For example, a hospital may charge $100,000 for a certain surgery that the insurance carrier may only pay $20,000 for based on pre-negotiated rates. Nonetheless, a plaintiff in suit could still seek the $100,000 at trial as the reasonable value of those medical expenses he incurred. This billed versus paid problem came to a head in a case called Howell versus Hamilton meets. There, the California Supreme Court held that an injured plaintiff whose medical expenses are paid through private insurance may recover as economic damages no more than the amounts actually paid. Howell was later extended in a Court of Appeal decision titled Hornbaum v. Lampkin, which concluded that evidence of the full amounts billed for past medical services is completely irrelevant and actually inadmissible to prove past medical expenses, future medical expenses, and non-economic damages. However, the Howell case and Hornbaum were limited to cases only where the plaintiff was actually covered by medical insurance. So what about uninsured plaintiffs? In Bermudez versus Silovec, the Court of Appeal rejected Howell's reasoning in cases involving uninsured plaintiffs. There, the Court of Appeal held that the amounts billed by medical providers for medical services are both relevant and admissible to prove the reasonable costs of medical services incurred. That brings us here to Pebley v. Santa Clara Organics. The issue there was whether to classify the plaintiff as insured or uninsured for purposes of Howell. In Pebley, the plaintiff had medical insurance, but he chose to receive his treatment outside of his medical plan through what's known as medical liens. The defendants argued that the plaintiff failed to mitigate his damages by opting for the most expensive method to pay for his treatment. However, the Court of Appeal in Pebley rejected this argument outright. A tortfeasor cannot force a plaintiff to use his or her insurance to obtain medical treatment. That choice, the court explained, only belongs to the plaintiff. However, because the plaintiff chose to be treated outside of his insurance plan, the Pebley court explained that the plaintiff was in the same position as an uninsured plaintiff and should be classified as so under the law. That being so, the plaintiff's full billed medical expenses were admissible to determine the reasonable cost of the plaintiff's medical treatment incurred. The fact that plaintiff chose to pay for his services via lien rather than through his insurance was completely irrelevant and properly excluded under Evidence Code Section 352 as being prejudicial. Pebley is going to have a profound impact on damages moving forward. Once plaintiffs retain attorneys, they'll likely always obtain medical treatment from physicians on a lien basis. Doing so allows plaintiffs to inflate their medical expenses in order to obtain a larger verdict at trial. If you're in-house counsel and have any questions about how this case is going to affect your bottom line, please reach out to me here at Buck Alden. Thank you.